Chapter 4, Privacy, Part 2 of 7, Laws Regulating Financial, Health, and Children's Privacy Online. The learning outcomes include: discuss and assess various federal laws that attempt to protect financial privacy. Describe how the government is using IT to protect consumer data that is private. Examine the evolution of laws that attempt to protect children online and explain why it's so hard to restrict the internet in the U.S. Explain the current state of federal regulations protecting children's data online, and evaluate how federal laws protect educational privacy for children and adults. Let's look at a few of the laws on the book to protect financial data. First is the Fair Credit Reporting Act, which regulates how credit reporting bureaus operate. They must allow you to access a free credit report at least once per year, and you must be allowed to contest items on the report and have them corrected where necessary. Second is the Right to Financial Privacy Act, which protects financial institution records from unauthorized scrutiny by the federal government. They may, of course, protect or check your financial information if they have a search warrant to do so. This act does not include disclosures to private business or state governments, so it offers less protection than you might think. You apply for a credit card at the Home Depot, they have a right to check your financial data. You apply for a job with the state of Georgia. This law doesn't protect them from learning more about your finances, but it does provide some protections for financial data only, and only at the federal government level. Here are a few other relevant financial data laws. We start with the Gramm-Leach-Bliley Act. This is recent regulation that was passed to give us more information on the financial institutes that we do business with. They must explain their information sharing practices to their customers and describe how they will protect our sensitive data that they have. This is why you receive important updates to how data is collected, stored, and saved. The Financial Privacy Rule allows you to opt in or opt out for receiving partner information for your data being shared. In the U.S., it is mostly opt out. You have to uncheck the little box so that they will not share your info. In the EU, it's all opt-in. If you don't agree to it, they don't have permission to do it. The Safeguards Rule requires most companies that collect and store your data to at least tell you how it's protected and when it will be shared. People get around these rules and access your protected personally identifiable information by pretexting. They try to fool people that they do have access by giving false statements to obtain your financial records. Pretexting is a problem with all types of data. Employees must know how to respond to these attempts and ensure that the person they provide with information is the one who should receive it. HIPAA allows continuity of health care insurance coverage due to a family status change, divorce, death, birth, etc. But it's so much more than that. Your personally identifiable health care data is probably the most protected data that we have. It cannot be shared without explicit written permission. If you inadvertently give out medical data on a patient, and if you have a great information security policy in place, it doesn't matter. You're still subject to huge fines for each record that is released. Healthcare data must be safeguarded and protected with strong information security controls, employee education, and the like. You can see here in this chart that most of the HIPAA data is still physically stolen. Someone picks up paperwork, or they make a copy onto a USB drive and take it outside the building. You must safeguard your healthcare data. There have been governmental efforts to move forward or move towards as much electronic health records as is feasible. The American Recovery and Reinvestment Act encouraged providers to computerize their records. It banned the sale of health information, required an audit trail, and provides patients with the right to access, review, correct, and update their health care records, much like you can do with financial data. FERPA is a law that all educators at all levels are familiar with. FERPA is the Federal Family Educational and Privacy Act and gives rights to those who own educational records. Until the age of 18, the parent or guardian of a child owns the records and may access, question, update, and review them as needed. Upon reaching the age of 18, the records are the property of the adult whose names the records are kept in. So if a parent of one of my students want to talk about their child's grades, I can't do it without explicit written permission. It doesn't matter who pays for school, who pays for the car, or who pays for health care. I cannot share. You bring your wife with you for an advising session. This really happened, by the way, for a graduate student. I can talk to both of you upon the student's agreement, the owner of the data, but I can't then respond to email messages from your wife. When that happened, I ended up copying the email from the wife to the husband who was the KSU student. I answered the email questions sent to his KSU email address and advised him that he could share with his wife if he chose to do so. Children, however, do have additional protections, or we've tried to give them additional protections. COPPA, or Children's Online Privacy Protection Act, attempted to give parents control over who gets and uses their children's personal information. It does not, however, cover dissemination of information to people via the internet. Most laws that aim to protect children online have failed miserably in being judicially upheld. It's a challenge. COPPA has been revised numerous times and typically, as mentioned, fails to pass judicial review. As this quote notes, you want to protect kids, but at the same time, I have a First Amendment right to look at that XXX website since I'm over 18 years old. How can you tell whether it's me or a child looking at the particular site? And who determines what is inappropriate without infringing on the rights of American adults? The First Amendment right to free speech in the U.S. is probably the most cited rule for allowing all sorts of speech that I may not like, but I or you still have a right to do. In fact, the movie The Post talks about releasing classified Vietnam War information. The courts at that time concluded that if national security did not trump freedom of speech, what would? You can take a look at this short video that describes some of the recent changes in COPPA. Several attempts to protect children have been unsuccessful, including the Children's Decency Act excluded minors, but it also excluded adults who had the right to view the content. Thus, it was overturned. Sexual expression that is indecent but not obscene is protected by the First Amendment. What in the world is meant by indecent but not obscene? And how do we determine if it's indecent but not obscene? If we use my standards, it would be perfectly correct for me. But how about you and others? I am not the moral authority for other adults. The government may not reduce the adult population to only what is fit for children. I don't want to search the internet for breast cancer and not be allowed to get there. But I can view children's toys and content included for them. Imagine if that's all we had online, stuff for children, intended for children, like what is on PBS and family channels. While that's good, sometimes I want to read about controversial topics or watch a scary movie that might have some bad language in it. The courts have determined that it's impossible to determine a user's age online. Require them to have a credit card? Okay, my boys had a credit card when they started driving at 16 years old. But you shouldn't have to have a credit card to view a website. Some people don't want to give out that information, and we can't interfere with an adult's constitutionally protected right to freedom of speech. If you want to block sites, then use filtering software. It's available for the home, and schools also have filters in place. Can you get around it? Well, yes, of course you can get around any control. Ultimately, I'm the adult and I need to protect my child. Finally, the court said, perhaps we do the minors of this country harm if First Amendment protections, which they will with age inherit fully, are chipped away in the name of their protection. Children must be protected by their parents when it comes to technology. To summarize, there are laws in the U.S. that try to protect personal privacy. However, the First Amendment bar is hard to overcome and many areas are not covered. When dealing with data from children, customers, consumers, employees, etc., you should use your own personal ethics and the ethics of the profession in which you work. There will still be gray areas, and you should do the best you can to abide by the law without compromising your ethics. When you store credit card information, patient healthcare data, or educational records, you must ensure reasonable security of the personally identifiable information. Reasonable security may vary depending on the data being protected, how the data is used, and the sensitivity of the data. Bottom line, you need to protect your personal data and the personal data of your children.